We have 6 items on the, what is going on here? We have 5 items on the agenda? Let me see.
No, got 6.
The agenda apparently, they were, okay. All right. We have 6 items on the agenda, which we will take in order. First item is Appeal 2979. The address for that property, 409, 411, 413 East Lancaster Avenue. The applicant, Scott Emerson, property located at 409, 411, and 413 East Lancaster Avenue, seeks a 1-year extension of time to obtain permit. Mr. Solicitor, this is the item that you would discuss with me in advance of the hearing?
No, this is not. This is just simply an extension request. This is the one where I'm going to have to get you the order that modifies the condition, which will
Fine.
send that out.
Understand.
But the other part of it is, my understanding from talking with your partner is, law partner, is that they need an extension of time. They're still in land development.
Okay, thank you for the clarification. I'll let counsel put that on the record. Please introduce yourself for the court reporter.
Jamie Jun here, last name Jun, for the applicant Scott Emerson of the Emerson Group. And as you've already stated, we are seeking an extension of time within which to obtain building permits. We're proceeding as quickly as we can, but we're still in the land development process and having to obtain land development approval as well as third-party approval such as PennDOT. We're seeking an extension of time. Currently, the 6-month expires on October 25th, so we will be seeking an extension of 1 year from that date.
Mr. Chairman, I have a question for the solicitor. Is this a matter that, well, two-part question. First of all, is this a matter that would have to be publicly advertised? And then secondly, was this publicly advertised?
No, and I don't know.
Second part wasn't for you.
And I have a question of the solicitor, which is, I know that when we have granted extensions recently, they've been for periods of 6 months as opposed to a year. Is that a matter of custom or regulation or law?
It's the 6-month extension for a continuance is a matter of code. The extension for permits, we generally only do 6 months, but there's no requirement that we do that, limit it to that. And this is a more major project than many that have come to us for an extension.
Do any members of the board have questions of counsel?
Yes. Is there a reason you're asking for a year as opposed to 6 months?
It's just, in abundance of caution, just giving us enough time to go through the process. As the solicitor has stated, it is a pretty complicated project, and you know, for example, we've had to go to the Planning Commission, I think 3 or 4 times. And although we are getting ready to go before the Board of Commissioners, we just don't know how long the process is going to take. And also, even after we get through the township approvals, there are other third-party approvals that need to be obtained prior to getting building permits, which is typically towards the very end of the process. So that's why we're asking for the 1 year. But again, we're trying to move, you know, as quickly as we can because it's in the interest of the applicant as well to get building permits and get moving on the project.
Thank you.
Any other questions? I'll entertain a motion.
I would move that the request of the applicant be granted.
Is there a second?
Second.
Is there any discussion on the motion? Seeing none, all those in favor of the motion granting an extension of 1 year to the applicant, say aye.
Aye.
Any opposed? None opposed. Extension's granted 5-0. Thank you.
Thank you.
Folks, don't expect the ball to go that fast. The second one is Appeal 2996. The applicant, Brendan Riley, for 400 West Wayne LP, property located at 400 West Wayne Avenue in Zone C1, seeks a variance from Section 280-103B regarding parking spaces and Section 280-105A regarding separation from street with other effective barrier against traffic, those sections of the zoning code, to renovate existing storage space to become a conference room for adjoining commercial space. Please introduce yourself to the board and let the court reporter swear you in, please. Use the Bible.
Sure. My name is Brendan Riley, and I'm here representing 400 West Lane
Okay.
LP.
And
Raise your right hand, please. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Mr. Riley, please proceed.
I'm sorry, just for the record, I am not related to Mr. Riley. I have never met Mr. Riley, and proceed.
Thank you.
Thank you, Member Riley, for that clarification.
So the reason I'm here is seeking two variances. I will go through both. The first one pertaining to subsection 280-103B, which is required parking spaces. The structure that is there today consists of 3 two-bedroom, 1-bath apartments and a existing commercial space that is 594 square feet. There are 7 parking spaces, so it is already an existing nonconformity. Per the requirements, the requirements are 2 parking spaces per dwelling unit and 1 parking space per 200 square feet of commercial space. So under the current code, the requirement would be 9 parking spaces, and there's currently 7. What I'm seeking to do is I own a small residential real estate brokerage, and I'm looking to relocate my office, which is on the corner of North Wayne and Lancaster Avenue, into this space. My wife and I own the LP, so we purchased the property about a year ago. The property was in, and still is in, a state of disrepair inside. I've been maintaining the outside while trying to go through this process. And our goal is to invest in the property and make it a nice corner of Highland and West Wayne Avenue. So what we're going to do is take an existing storage space that's there, stay within the footprint of what is there. I'm proposing that we have to bring it down because I don't believe there's proper footers underneath of it for what we need to do. We would not change the footprint of that. We would then convert it into a conference room and connect it to the existing commercial space, which would take the total square footage to 811 square feet of commercial. So under the code, the requirement for parking would therefore be 11. I have 7. So I can offer 2 parking spaces to every dwelling. I've been in business for 5 years. I'm pretty much a sole proprietor. I don't have a staff. I don't have office. It's just going to be me going in and out of the office. I may conduct 1 or 2 settlements a year out of that office, so I don't really have the need for the additional parking space. And if it would please the board in looking at this, I could easily either remove 6 square feet from the total project to get to 799, which would then eliminate the need for 1 additional parking space, bringing me down to 10. Or I could take 12 square feet from the addition, putting that at 199, which would again put the total requirement at 10 versus 11. So I'm seeking the minimal amount of variances as I can. There is a side yard. This lot is in every sense with what's there non-conforming because of it's a double front yard. If you look at the site plan that was included, nothing about what is built there today could be built under today's code. And also, we're looking to enhance the property. The front porch is in a state of disrepair. It's falling down. It's a wraparound front porch. We're just going to replace the front portion of the front porch, so we're going to also be decreasing the impervious coverage at the site overall. So that's the variance we're seeking for subsection 280-103B. The second for subsection 280-105A, which is a separation from street with other effective barrier against traffic. That's already existing nonconformity. We're not looking to change what is there.
Take a second. Do members of the board have any questions of the applicant? How would you describe, on a normal business day, the circumstances around there for street parking?
Around that, it's predominantly residential. There's a church across the street. There's a vet, Caddy Corner, who has its own parking. I haven't been there enough to know. I think there's a lot of residents that probably leave for work, and there is on-street parking. I can tell you my current office right now is less than 400 square feet. So I don't have people coming in and out. I don't actually even conduct settlements there. So part of the reason I'm doing this is so that I have the ability to conduct settlements for my clients in-house versus out-of-house.
Practically speaking, what are you envisioning? That when the clients show up for the closing, the residents are going to be gone and they'll pull in for an hour or two? Or do you think that there are in fact going to be spaces where they're going to
I
park
believe
on the
there'll be
street?
plenty of spaces on the street. I also believe that my tenants will be at work. I have 6 parking spaces there, so I believe that I'll have open parking spaces. A real estate settlement will take place between 9 a.m. and 4 p.m. generally because of bank wires, and they don't usually last more than an hour. So I don't see it being a burden on the neighborhood. And as I said, I do about 30 transactions a year, so I might do, half of them are buyers where my clients may want to settle at our site, so it may be 1 to 2 closings a month.
Again, any questions of the applicant?
So this is an existing nonconformity for both the setback from the street and the number of spaces?
Correct.
Correct. And that number is not changing? You're not increasing that nonconformity?
I would be on the parking, and it would either be so what's required as the property sits today is 9. With the addition that I'm proposing, or the repurposing of the space, it would be 11.
Well, the
Because
requirement will be 11, but you're still going to be at 7?
Correct. That's correct.
Okay,
Yep.
got it.
And I could also modify the plan slightly to make it so that the requirement's 10, but it's either 6 or 12 square feet, depending on how the code is interpreted.
And your addition is conforming in all other respects? For
It's all-
setbacks and all that kind of thing?
We're not going to change what's currently there, so it's all existing nonconformities. The entire
Okay.
building is, because it's on a corner, it's very narrow and very deep, so nothing there is within the building setback.
So this space is used as storage,
Correct.
as storage space now, and you're going to renovate it, not going to exceed the space and maybe even shave it a little bit to get another parking space.
That's
But
correct.
it's converting commercial storage to commercial conference room,
Correct.
office, that type of thing.
That's great.
Stand
And
by.
how many feet is involved, I'm sorry?
I'm sorry?
How many feet is involved, square feet is involved?
As it's planned right now, it's 211 square feet would be
Okay.
added, and the total project would be 805 square feet, including the existing. And again, I would certainly be happy to take that down to 799, or take the conference room down to 199 to reduce the variance being sought.
Mr. Riley, stand by for a second. Is there anyone in the audience who wants to speak to this application? Okay. With that information, again, are there other questions from members of the board? I see our solicitor is perusing the code.
Yes, he is. The space right now uses storage, but it's still part of an office complex, right?
Correct, it is attached. There's a party wall between the two.
Okay. It depends, quite frankly, on whether we count this as office space now, in which case, the nonconformity would be grandfathered under 10311, or whether we deal with it as some use other than office, in which case it's one space for each 1,000 square feet. So he would be at least grandfathered as to 8, I think. The law on these, on parking, where parking can't be prohibited, and we've had this many times before, is that the owner has to have a reasonable use. That does not mean they get the most parking intensive use out of available uses, but they've got to have a reasonable use of the property and of the space. So for example, let's say you've got 500 square feet and their uses that are from 5 to 20 spaces. The applicant doesn't automatically get a right to 20. He gets a reasonable usage, and it's up to you to decide where south of 20 and down to 500 that use would be.
I am finding myself sympathetic to the application. I note we have no expressions of opposition. You mailed out notices per the instructions of the township. So I'm not sure how much pain and suffering we want to go through on the issue of hardship, or whether we want to move to a motion. If somebody disagrees with me on my first premise, jump in, but.
Well, I'll just start with I'll make a motion to accept the application for the variance.
So the motion is to grant the relief requested. Is there a second on the motion?
I'll second.
Okay, then I'll pause for a second to make sure the board has a chance if they want to have questions or further discussion. No one is, I'm seeing some puzzled faces, but no angry faces. So I'm pausing. No discussion. There's a motion that has been seconded. I'm going to call for a vote. All those in favor say aye.
Aye.
None opposed. It's approved 5-0. You have your
Thank
relief.
Can I ask a quick question, just for point of clarification?
This is off the record.
Off the record? Thank you.
The plan as proposed was approved, correct? Okay, thank you.
Okay, the next item is Appeal 2997, 791 Darby Road. Do we have representatives here for that one? Okay. Appeal 2997, the applicants Leif Zetterberg and Dr. Eric Zetterberg. Property located at 791 Darby Paley Road is zoned R1. Seek a variance from Section 280-1 of the zoning code to install a second kitchen on the basement level to provide ADA access for aging parents. I'd ask counsel to introduce himself for the court reporter and the record, and then have your witness introduce himself and be sworn in.
Yes, good evening. My name is George Brosman. I'm representing the Zetterberg family in this application, and beside me is Leif Zetterberg, the owner of the property. I'd ask that he be sworn in, and then I'll have a brief opening remark and call him as a witness.
Sorry.
Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you. Thank you.
So I've handed out an exhibit package that will go through with the testimony of Leif Zetterberg, but Leif Zetterberg is the record owner of the property that's the subject of this application. He lives there at the property with and is the caregiver for his elderly parents, Dr. Eric Zetterberg and Leif's stepmother, Mabel Zetterberg. Dr. Eric Zetterberg, as the testimony will show, is about to have his 94th birthday, I believe later this week, and Mabel Zetterberg is 83 years old. They have conditions, as you might imagine, that require that they be placed in a part of the home that has handicap accessibility and is safe. Leif will speak about that. A little background, Dr. Zetterberg built the house in 1968. He lived there with his wife and 7 children. He had for many years at the lower level of the house a dental professional dental office for his practice there. And it is the proposal to basically convert that dental office space, which has not been used in some years, into a handicapped accessible living space that will include a kitchen. It's essentially the kitchen that brings us here this evening, because it'll be a second kitchen in the dwelling house, so that needs relief. The testimony will show that the topography of the lot and the configuration of the home make it necessary so that the only essentially handicapped, accessible, and safe place for Eric and Mabel to reside in the home, and they do desire to stay in the home, is in the lower level where the former dental office is. So I think there is hardship here in this case that you'll see through the testimony. I also think there is the Fair Housing Act amendments that talk about a handicapped person getting a reasonable accommodation to stay in the dwelling of their choice. So I think that the board could approve this under either hardship grounds or under the Fair Housing Act, which recognizes that an accommodation should be made to handicapped persons. The testimony will show that their physical condition, they do meet the definition of handicap, as I understand it. So with that introduction, I'd like to have Leaf testify.
What is this space presently used for now? Is it just empty space?
Yes, but why don't you, Leaf?
Yes, my father stopped the practice a number of years ago, and it's just pretty much remained dormant.
So there's no, it's not used as part of the house, it's just sort of a...
You walk through it to go up the stairs. That's pretty much it, yes.
Sorry, I didn't hear.
Oh, I'm sorry, yes. We would walk through the lower level to go up to the stairs because it's accessible from the driveway.
There is a handheld mic that if you turn on, perhaps you can use for your testimony for the benefit of the court reporter.
Does it work? Can you hear me? Oh, okay.
Leaf, are you the record owner of the property at 791 Darby Paoli Road?
Yes.
In the exhibit package that I've handed up at Exhibit A1, is this a copy of the deed that shows you as the record owner?
Yes.
And you recently, that was transferred in this year to you from Eric and Mabel?
Yes.
And do you live at the property with Eric and Mabel?
Yes.
And are you their caregiver?
Yes.
Can you confirm the ages I mentioned in my opening remarks of Eric and Mabel?
Yeah, my father's will be turning 94 on the 14th of this month, and my mother's 83.
And how long have you lived there at the property?
Since my father built it in 68.
And obviously your parents owned the property before transferring it to you?
Yes.
With regard to existing conditions at Exhibit A2, is that a survey of the property? We can put that up here.
Yes, that is.
And can you quickly, for the record, describe the property?
Yeah, the property is kind of like a flag-shaped property. The house sits up on the hill here. The driveway is about roughly 300 feet, a hill, 300 feet. So this is where the house is. And then we have steep elevations to pretty much all sides of the house. The house is the flat area right here. I'm sorry. Right here is the flat house area. My father had it excavated out for building purposes to put the house up. So it used to be more of just a steady slope going down.
And is there a flat portion of the driveway adjacent to the house?
Yes, as you come up here, it's just steep driveway up here, and then right in this area is where it's flat for parking.
And when you're saying this area, it's generally to the south of the house?
Oh, that is correct, yes.
And that flat area for parking, where do you enter the house at grade without needing to go up any steps?
Yeah, if you when you come up and you park here, there is a door right here to the left of the building right here where the patients used to come in directly into the office area.
So is it only that lower level that is accessible at grade to the driveway?
Yeah, that's correct. The hill starts right at pretty much the end of the south end of the house here. Going up, it's a hill.
And as the board will note, you can see the steep slopes are marked in the gray, and you can see that they go on either side of the house, and that's why you have to go in at grade at the lower level. Describing the house now, there are 3 levels, is that correct?
Yes.
And describe briefly each level of the home.
The first level where we have the door at the entrance, that was originally the dental office. My father's practice was there for a good number of years. The next level up, there were 2 levels above that. So you would climb a set of stairs. The second level, that is where we had our family room, kitchen, dining room, living area. And then there was a 3rd level where all the rooms and the full bathrooms were. The full bathrooms are upstairs on the 3rd level.
And when you say all the rooms, do you mean the
Oh,
bedrooms?
I'm sorry, yes, bedrooms. The sleeping quarters were upstairs, yes.
And the full bathrooms on the 3rd level, correct?
Yes.
And is it still that way today?
Yes.
Now, due to the topography of the property and the orientation of the lot, is it possible to reach the bedrooms and the full bath facilities without going up a number of steps?
No.
In addition to the stairs that you've mentioned and the steps, are the upper floors of the residence designed to provide for handicap accessibility?
No, it was really designed for a family. The doors are narrow. They're not really wheelchair compatible, and none of the bathrooms have the proper handrails or showers or even bathroom toilet facilities.
Now, turning your attention to Exhibit A3, is this a series of photographs that you took?
Yes, these are photographs of the house.
Can you just run through these for the record using the numbers, image 01 through 04? Describe what they're showing.
Okay. Image 101 that we're looking at is the front facing of the house. That's the front door. If you will notice, in order to get to the front door, there are a series of stairs from down at the parking level up there to get entrance into the 2nd level of the house. That was the first living quarters that I described, with the kitchen, the dining room, living room, library. The upstairs, the windows up there, are the sleeping quarters, the 3rd floor, that also required stairs to go up there currently.
And image 02 is the one of the sides of the home?
Yes, this is the back. This would be this is that side of the house.
The left
The
side
left
of
side
image
the house.
01?
Left side of image 1. Yeah, thank you.
Now turning to image 03, is that the rear?
Yes, this would be the opposite side of the front of the house that we looked at. This is where again, the kitchen, dining room, family room would be, and these are our living quarters at the top, windows with the living quarters up there.
And similar to image 1, you can see the grade sloping off to the left side of that image, is that correct?
That is correct. There's a steep hill right here.
Now, image 04, is this the other side of the house, which would have the entrance into the former dental office?
Yes, as you can see, this is the only door on the lower level that's in line with the driveway where you could park and go directly into the house. From this point on inside the house, you do have to take stairs to get up to the living quarters.
And that's the driveway?
This is the driveway.
In the foreground?
Right, yes, top driveway right there.
Do both of your parents have physical conditions that substantially limits one or more of their major life activities?
Again, my father right now is suffering from macular degeneration, and he is losing his hearing. His mobility, he's not very stable. He uses a walker to get around. My mother's hearing is going, her sight is good, and she has a little issue with mobility at this point. She's steady, but just has some mobility, uses a walker as well.
And does she also assist in meal preparation for your father?
Yes, my father does require, because of some swallowing issues and stuff, he does require thickening of things and special diets and food. And my mother's a great cook, so it's a shame she has to go to all this new stuff for my father just to comply with what the doctors would like him to eat now.
And this is part of the reason why it's important to have the kitchen down in their unit?
Yes. Yeah, she will continue to cook for him.
With regard to the proposed plan, I stated this, but is it your parents' desire to continue living in their home?
Yes, it is. My father loves the area. We were driving around as kids, he always said, this is the best place to live. So he would just like to stay here.
And given their condition, is it possible for them to remain in the upper levels of the house?
No, they're just climbing stairs at this point, and it's just an accident waiting to happen. And this was our concern all this time, was just to get them off the stairs, allow them to live their normal life without having to climb stairs to either bathe, to sleep, or come down to eat.
And for the record, I'm not going to go over it, but Exhibit A4 is an existing conditions of the floor plan of the lower level. existing A5 is the proposed layout for the living unit. Is that correct?
Yes, this is correct.
And given your parents' condition and the physical conditions of the property that we've discussed, do you believe that they can be reasonably accommodated in this space as opposed to the upper floors of the home?
Yeah, the space that we're providing, first of all, eliminates them having to climb any stairs, and we are making it wheelchair accessible and putting everything in place for their normal living.
And would there be any major exterior modifications to the residence that would change the appearance of the home from that of a single-family dwelling?
No, the only one change is we're required to put in a second egress to comply, which we are, and that will go right over here. So that's the only outer wall that we'll be touching, and that's just to be up to code.
And when you say over here, the rear of the...
I'm sorry, forgive me. Oh, yeah, on the map, it is the rear of the building towards the front, where the driveway was.
You've lived in the neighborhood for many years. In your opinion, will allowing the cooking facilities in this living unit have any detrimental impact on any neighboring property or the township's public health, safety, and welfare?
No, I don't think it will not add any detrimental issues at all. I mean, I think it speaks volumes to the township to allow my parents to live there. They've been there for 50 years, to allow them to continue. I think that just speaks volumes to our ideas of allowing our elderly to live in the community with us.
And if the board were to grant this approval, would the family be okay with a condition that essentially says that the living unit has to be occupied by a relative of the remainder of the unit?
Certainly, yes.
In other words, within the definition of single family.
Correct. And
By the way, I noticed that what they referred to as A5 actually has an A3 at the bottom, but it's an A5 on your thing, so I just marked that A5. So
yes, the A3 was part of a larger architectural plan set, but A5 for my package.
Council, were you responsible for sending the notices out to the neighborhood, or did?
Yes, we did submit a letter to the township, and all of the notices were sent out.
Thank you. Is there anyone here who is here to speak to this application? John, could you very briefly remind the board of the requirements to provide under the Fair Housing Act, the requirements?
The Fair Housing Act, it's federal law, so it's superior to Pennsylvania law, including zoning law. In a nutshell, it says that reasonable accommodations have to be made in local ordinances, including zoning ordinances, to give disabled people a right, an equal opportunity for housing. This means that variances may be required under the Fair Housing Act as a reasonable accommodation that would not be available under Pennsylvania law. Here, they're willing they're willing to say that the house home will only be a single-family home, and you know, the board has to find that the parents are disabled.
Thank you. Do any of the members of the board have any questions of the applicant or his counsel? Seeing none, does anyone want to make a motion?
I move that the applicant be granted the relief requested, and
Is there a second?
Second.
Before we continue, can we agree that the motion includes the limitation that council volunteered and that our solicitor referenced?
yes, I'm happy to amend. Can we amend the motion? Yeah. I'm happy to amend the motion to provide that the applicant be granted the relief it is requesting in accordance with the requirements of the Fair Housing Act.
Okay. And it's,
I second the amended motion.
all right, any discussion on the motion as amended? Seeing none, all those in favor say aye.
Aye.
Aye. None opposed. Good luck with your project.
Thank you very much.
Appeal 2998 428 Luella Avenue. Is the applicant here? Okay. The applicants, Rick McMonigal and Kathleen Chantclear, property located at 428 Luella Avenue and zoned R2, seek a variance from section 280-20D1 of the zoning code, or alternatively a variance from section 280-22B of the zoning code regarding minimum separation between accessory structure and principal building or any other zoning relief required for the purpose of installing a hot tub. And when council's ready to proceed.
Evening, Nicholas Cornelia, representing the McMonagals. Kathy, stand up. You may testify too.
Okay.
You want to swear them in?
Will you raise your right hand?
Listen. Just both of them.
Do you swear the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
We do.
We do.
Council, please proceed.
Yes. Rich, are you and Kathy the owners of the property in question?
Yeah, we moved here in about 5 years ago. We've been lifelong Delaware County folks. Moved from Drexel Hill, downsized a little bit. The kids moved out. We were looking for a place with a village, so we checked out Media, we checked out Westchester, because we've always loved Wayne. I went to Villanova, my wife did, my dad did, my sisters did, and anyway, we wanted to be in a place that had a village where we could walk to the village, and we ended up getting that with our place on 428 Luella, which we just love, and hopefully, like Dr. Edinburgh, I'm going to be here the next 25 years. We plan to stay in that house as long as we can.
I'm going to show you what's been marked as A2. Unfortunately, I have two attorneys as clients here, so it's probably going to be windy, the testimony from the witnesses. I'm going to show you what I've marked as A2. Is that the deed of the property?
Yes, it is.
And then I'm going to show you what's been marked as A3. Is this a survey performed by Duncan Hughley?
Yeah, I hired Mr. Hughley at your recommendation.
And does this accurately represent your property?
It does.
Okay, and you're conforming, currently, you're right up against the setbacks of 20 feet and 25 feet?
Yes, where we're proposing the hot tub is the 25-foot side. That's the bouquets. The other side with the driveway is the 20-foot side.
Okay. And actually, you're still maintaining a setback of over 20 feet on the side where the hot tub is. It's just the aggregate will be less than what is required.
Yes, if the board was kind enough to grant this, yeah, there would still be 23 feet between the little part of the hot tub that's going to stick out and our neighbor's property line.
Yeah, and actually you have 20 feet 7, and we talked about this the other day. I believe that 20 feet 7 is part of the concrete pad and not actually part of the hot tub. Is that
Yeah,
right?
my understanding is if you want a hot tub, you have to have it, it's got to be on at least a 6-inch concrete thing. The hot tub we were looking at was about 7.5 feet by 7.5 feet square, but the cement is actually a little bit bigger.
Okay, so again, you are maintaining the 20-foot setbacks. It's the aggregate of 45 feet that's being violated that we're asking for relief.
That's correct.
And again, this is Luella Avenue showing your front yard, and this is the area where the hot tub is. Now, have you spoken to this neighbor? In fact, I believe we have a letter from him, right?
Right. In fact, if you'll give me a second here.
Well, I just asked, have you
Okay.
spoken to the neighbor first?
Well, I have, and the two letters are
Okay,
exhibits.
All right, fine. For approval.
Yes, we have Jeff Bouguet and his wife Mara. She grew up there, and they just bought from their mother, and they got a little kid. They're going to be here the next 25 years.
Okay. Now, why are you proposing a hot tub in this particular area? And maybe, I don't know if the board has this. I've marked it as A3A, which goes in it shows the area, but then indicates some items that are in the yard. I'll hand this up. I'm not certain if the board has this or not. It's A3A.
I have it as Exhibit A3, and I think you did have, at least I did, as A3, and A3A seem to be the same, so I'm looking at both of those.
So we're looking at A3A, though, because that's
All
what
right.
I've marked and I've handed up.
Okay?
And before we get to A3A, let's look at some of the photographs of the property so that the board's familiar with it, I believe, to make it more familiar. First, A4, what does that represent?
That's the front of my house shot from Luella.
A5?
Yeah, and A5 is if you were looking at the left side of the front of my house, and that is actually the side yard. And one of the things I'd like to point out for the board, if you look at the front A4 and then A5, the way my house is set up, there's actually a slight
Your house is
grade.
on the right-hand side of A5.
A5 it is. So if A4 is my house, my yard sort of slopes from the back down to Luella. It's a little slight grade, but it's a pretty steady downgrade from the backyard all the way to the front yard. And if you look at A5, which is the Bouguets is on the left side, my neighbors, my house is on the right of A5, you can actually sort of see there's a little bit of a slant downward. The grade goes a little bit toward the left, so there's something of a little like a swale almost in between. So the natural drainage of my house is from the backyard to the front yard, and it also sort of goes to the left a little bit toward the Bouguets.
Showing you what's been marked as A6, and if you can tell the board what this represents and where the hot tub would be located in that photograph.
Right. So this is actually shot, that fence sort of starts my backyard. We have a dog, a beagle, so we have to, have everything fenced in there. So that is the side of my house. You can see there's a little cutout there on picture A6. So there's going to be a door right there where that cutout is, and that's where you would step out. And again, if the board were kind enough to grant this request, the hot tub would pretty much go between those two windows that are shown on Exhibit A6, between the two windows on the left there. So you would come out the door there, there'd be a little walkway, and then the hot tub would be there.
I'm going to show you what's been marked as A7. Is that kind of a similar photograph?
That is the side of my house, looking at it from Luella. You can sort of see the air conditioning units. We've got like a lot of little trees and bushes. The hot tub would be behind the side window there. You actually can't see it, but that's the side of my house looking at it. You basically wouldn't be able to see this thing from the Luella Avenue.
Okay, and actually, how about, would there be any screening between you and the Bouguets so they wouldn't be able to observe it also?
My plan would be, if you'll, again...
All right, we'll get to that.
Don't worry.
No, let's move on. All right.
All right. Well, the answer to your question is, yes, my plan is to have some evergreen trees to give some privacy to the hot tub. So basically, the Bouguets, won't be able to see anything but evergreen trees.
Okay, A8?
That's a similar shot to the one we just saw. That's a little more toward my backyard. Again, looking at the left of the photo, the hot tub would sort of be between those two windows in the left, and you can sort of see where the door would be. That's coming out of a first floor master bedroom.
And A9?
Same shot here. You can actually sort of see there's that's really showing my backyard and sort of circling around to the driveway side. There's about an 18-foot like berry tree that's right there on the corner of my house. That's the backyard.
And also that photograph shows some wires up there as well?
Yeah, the power to the house comes, we don't have telephone poles in the front of the house, they're in the back. So the wires run from sort of like the peak of my house, and they sort of run diagonally toward, I guess, the property line where they join. I'm sure the Bouguets do the same. You can actually sort of see on the photo or the picture or the graph, whatever, A3A, I sort of drew the way the electrical lines sort of go from sort of the corner of my house or the side of my, and they go to the backyard. They sort of shoot over the backyard.
And A10, is that just showing the rear of your home?
Yeah, that's the rear of my house.
And showing the patio?
Yes.
Now looking at A10 and A3A, is there a reason why you're locating this hot tub in this particular area?
A couple of reasons. One is, actually, people may not realize this, but when you use a hot tub is January, February, and March, not in the summer. So you're sort of freezing your buns off as you get in. So being closer to the house is actually a good thing. Plus, this is very pathetic. We have no grandkids. We don't have anybody married yet, but one of these days we're going to have grandkids. And the less you have to run for slipping and stuff like that, it's better to have a minimal distance to go from the house to the hot tub because of ice and things like that. We also have, just love this house. It was redesigned in 2005. It was a Cape Cod, and then they put on a family room in the back there, and they put on the patio. But as I started to say in the beginning, like a lot of houses in Radnor, we have a little bit of like the drainage issue. We have 2 sump pumps. And the previous owners, the Donovans, actually invested in a drainage system that, runs along the back of the patio and the gutters, and it's underground, and they have little mini channels and PVC channels, and I'm assuming they ran it by you all back in 2005. But there's a drainage pit that's about 6 foot by 7 foot of 3/4 inch crushed stone that's 5 feet down and sort of panel, and then it sort of works its way over to that swale over by the Bouguet's property. So the gutters go in. We have this sort of underground water French drain trench thing that helps keep the place dry.
Is that directly behind what is listed as a flagstone patio in your home?
Yes, if you see, and again, this is
I'm just going to mark I've marked as A14, and you just brought 2 copies in, but I'll hand.
And I have another one. I was digging around today in the house. There's another one, Nick, if you want. There is actually
Why don't you just explain what A14 represents?
yes, so there's an actual, this came when I bought the house, and I just sort of discovered it today. There's a blueprint. You're just seeing a corner of the blueprint because I have a little HP printer that only prints 8.5 by 11. But the backyard drainage, you actually can't see the drainage pit here, but this was a design for the patio, which was built in 2005, and it just sort of outlines here how they did the drainage, and then where the mini channels were and things, and then the drainage pit, I guess you call it, or trench, is over here on the right side, and this is what, again, the prior owners put in to help deal with the water issue, which is an issue I think we generally have at different places. We do have 2 sump pumps in the house, so our basement's perfectly dry and all that, but I think drainage was something they were thinking about, probably because when they built this patio and the flagstone, they had to do the whole impervious thing or whatever, and so now we do have the trench there where it's shown on this thing.
Okay, and any other reasons why it's being located in that particular area?
Well, so if you go back to, I guess it's A3A, the hardship that I'm able to avoid by putting it there, first of all, it's closer to the house, so it's farther away from my neighbors. So when I showed it to them, they said, boy, we really love that plan. It's close to the house, it's tucked in there, but I also can totally escape having to deal with the trench and the underground piping and the gutters. It's actually before my corner gutter there, so I literally don't have to consider the underground trench and drainage. All I have to do is, I guess, when they put the concrete pad in, just tilt it, whatever the engineers do, they just tilt it a little bit, but it's the most effective way in keeping my drainage as it exists right now and not upsetting the present drainage.
Would this also not affect the tree that you referred to, that 18-foot berry tree?
Well, another option would be, well, gee, Mr. McMonagle, why don't you move it there and move it inside the property line? But at that point, then I would probably have to chop down that tree, and it's an 18-foot tree. I'd rather not chop down the tree if I can avoid it, because I don't like chopping down an 18-foot tree. But that's at the corner of the house there, and that's if I put the hot tub there.
Okay, now I've shown you, I'm going to show you what's been marked as A11. Can you describe what A11 represents?
Right, and probably what I should tell you first is how I got A11, because I prepared this, and I am not an artist by any means, but you can sort of do like a Photoshop with a picture. So this is actually one of the pictures that you have as the exhibits, and you can make it into a line drawing. And then I tried to draw what the hot tub would look like, but it is not, what do I want to say, the angles and things don't quite line up the way they should. If I was an artist, you could do it. But I wanted to give the panel at least an idea of what I was thinking of. So you would sort of come out that door, there's a little pathway to the hot tub, and then there the hot tub would be tucked up right up at the house between those 2 windows.
Now, I asked you about screening and buffering, and that A11 doesn't really indicate all the buffering. Can you describe what buffering you would do here?
Right now we have some sort of scrubby little bushes there, and what I like to do, if I put exactly what I wanted, you wouldn't have been able to see the hot tub, so you really wouldn't have been able to envision what it was I was thinking of. But what I'm envisioning is more like evergreens that would be, 4 to 5 feet rather than a typical hot tub. By the way, just so you know, for the size of this thing, because you might be wondering, but I was looking at the podium here and this table. That's probably, it's about 7 to 7.5 feet. So that is sort of square what we're looking at. But my plan would be to have, evergreen trees or whatever sort of coming out this little pathway here. So basically from the neighbor's side, you wouldn't be able to see anything, and certainly from the front yard, you wouldn't be able to see anything.
And also that would give privacy to both you and the Bouguets.
Right,
Regarding that.
exactly,
Yeah.
exactly.
Right. Now, we had mentioned the Bouguets had written a letter. I'm going to show you what's been marked as A12. And also, is that the letter from the Bouguets having no objection?
It is. We're, we're a little friendly with them, so we talked to them. They said, gee, can we write a letter? They even offered to come here. They have like a 2-year-old, and they're both work, and I just couldn't see dragging them out here tonight. But they said, can we write you a letter? And I said, gee, that would be great. So they wrote this letter, and I think there was a little posted thing as well.
Yeah. And you had mentioned that they like this location as opposed to another location you could put it. I mean, there's
Right. There's my
under the
understanding-
Radnor code. Yeah, go ahead.
Right, there's like an option, a 10-foot kind of option, be 10 foot from the house and 10 foot from the property line and stuff like that. If it's considered a separate structure, I mean, this is really Nick's area, but that would actually move the thing closer to their house. I actually thought having this thing tucked into that little nook there, not only is it closer for my benefit, getting out the door and not slipping and doing all that stuff, but from their benefit as well, it just tucks into the house and they really won't be able to see it.
Okay, and also I'm going to show you finally what's been marked as A13.
Yeah, that's just a post-it. When they sent me the letter, and I guess I gave them a copy of the plans. So they put that little post-it on the plan, said, hey, we like it. So the thing I gave you, I gave to them.
Okay. I have no other questions.
One question. Is it fair to assume that the hot tub, you're not having it custom made, you're buying it?
Right. I try to buy local, right up at Berwyn.
Okay.
They have a jacuzzi place, and so I've looked at them.
Questions from the board?
Yeah, I just want to confirm, on Exhibit A5, if you're looking at that picture,
Here we go.
okay,
I'm looking at it.
okay, the property on the left is the Bouguets?
Yes.
Right.
Yes. And I'm on the right, and you can't quite see because there's like a big bush there, but the hot tub would be like sort of well beyond those like big round bushes there.
Okay.
We have a quiet board tonight. Council would, if we twisted your arm, is it de minimis or is there hardship?
I think it's de minimis and a hardship. I was going to answer that way. I don't know. I think it's actually
Why don't
both.
you
It's
try
very
to
small.
articulate both arguments?
Okay. As to the de minimis nature, as we mentioned, we're actually complying with the 20-foot setback. It's the aggregate setback of 45 feet that's being violated here. And it's actually being violated by only a couple feet when you look at the aggregate. For the de minimis nature. As far as the hardship is concerned, as Rich had mentioned, we have a drainage system going directly behind the patio of this home. We're all aware of water issues in Wayne itself. And as well, we have a tree, and also, as we know, there should be proximity to the house when you're dealing with a hot tub. But I believe the main issue from a hardship would be, one, the tree, and two, the drainage system would have to be torn up and relocated if this hot tub was placed behind the home.
I want to take a second. Is there anyone here in the audience who's here to speak to this application? Okay. Again,
Mr. Chairman, if I may ask for the exhibits to be made part of the record, please.
Okay, the exhibits have been,
A14.
All of them.
all the exhibits have been admitted. Again, do other members of the board have questions of the applicant or his counsel? Seeing none, I will invite a motion.
I move that we grant the variance.
There's a motion, a second.
Second.
Well, let's take a second for some quick discussion, which is, I am sympathetic to the application and the request. I'm struggling with the legal justification. And I think of perhaps two challenging approaches. I would probably prefer de minimis.
Yeah, Mr. Chairman, I would agree, and if my colleague, Mr. Hirsch, would consider revising the motion to specifically state that the variance is being granted on the basis of it being a de minimis variance, I would be fully supportive of that.
I would agree to your amendment and would move that we grant the variance based on the fact that this would be a de minimis change to their setbacks.
With that correction,
I second that.
an amended motion has been made and seconded. An amended motion has been made and seconded. Any discussion of that motion? Seeing none, all those in favor of the motion say aye.
Aye.
Aye. None opposed, it's approved 5-0. Thank you and good luck.
Thank you.
The next item for consideration is 333 Chaminade Road. I've been around for a long time, but I don't live on that street. The applicant is here. The applicant, Patricia D. McKenna, property located at 333 Chamonix. Chamonix Road. And
You'll get it
zoned,
by the end of the night.
that might be the last time I have to say it, and zoned R1. Seek a variance from section 280-15D1 of the zoning code in regards to required side yard setback and any other zoning relief, required construction, in addition to the corner of their home. I don't think this language came from council. I think there may have been a typo there. But that having been the public advertisement I've read, council, please introduce your witnesses and swear them in and proceed.
Raise your right hand, please. Swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Okay, Steve, actually, Patty's the owner of this house. Okay, all right. And I've marked as
Please
A2.
be sure to use the microphone and respond.
I'm
to
sorry.
questions.
I've marked as A2. Is this a copy of the deed?
Yes.
Okay. And A3, I'm going to show you what I've marked as A3, Steve, and if you can tell the board what this represents. And actually, just by way, we are, what Steve's doing here, what the McKennas are doing here, they're squaring off a very tiny portion of the rear of their home. That's all that's really occurring here. So I'm showing you what's been marked as A3, and this is a survey of the property.
Yep, it's about 1.3 acres altogether. Chamonix Road's down here. You go up the hill to our property. Our home's located within the building envelope up here. This extension that you're looking at right here, back in, the home was built in 1927, and back in those days, they used to allow access to the other end of Chamonix Road up here so people could walk to the train. So we actually own this 5-foot by about 300-plus foot extension. That's what you're looking at there. So the closest properties are over 300 feet away over here, 400 feet away over here, and similar distances as you go around. So for this application, I believe the rear of the rear yard is defined as being this side that you're looking at here.
No, actually, the rear yard, here's Chamonix, I believe the rear yard is here. See, that's the 40 feet.
Okay, yep. Mm-hmm.
And
So this is side yard, and front yard.
Right. And this is, you have actually a garage there, 1.5 story, and that's not what we're referring to. We're referring to the existing home. Is that right?
Correct.
Okay. And currently, how many bedrooms, how many baths do you have in the home?
The home has 3 bedrooms and 2 baths on the second floor, and the first floor has a powder room.
Okay, and you're proposing an addition to the home, and actually you're extending the home? Is that what we're doing here? I'm going to show you what's been marked as A4. And if you
Yes.
could tell the board what this represents.
So we're proposing to make my wife is visually impaired. At this point in time, we're both in our 60s. So with the 3 bedrooms being upstairs and only 3 bedrooms in the house, we're going to take what is an existing room downstairs, make it into a master bedroom with a master bath down, and adapt essentially to the exact same footprint that we have right now. We're going to keep that and just square out this corner of the house right now, which is an existing patio, so there's no additional impervious cover there. And if we were to, typically we enter into the house from the driveway through an entrance right here, and there's no break in that room. We don't have a mudroom set up, and we don't have the ability to drop things as you would, coming in from the outside to the inside, nor any wind break. So we're going to create a mudroom addition, or a very small addition of about, I think about 30 square feet to the existing portion of the house right there. And that's really the full extent of the variance request is about 20 feet altogether. It's just a little corner that sticks out about 5 feet into the building envelope.
And actually, there's, as you mentioned, it's a corner. It actually tapers to less than 5 feet as you move back toward the envelope.
Yes, literally that little triangle right there is the variance.
I'm going to show you some photographs that I've marked as A5, and if you go on A through H, and if you could just tell the board what those photographs represent.
So you're looking at the rear of the house here.
You remember to say which one, A.
Okay, we have a 1-story addition to the what was the original 1927 house. That's what is there right now. We're going to keep that same foundation that you have of that addition. We're going to take a mudroom. We're going to bring it off of the left-hand side of the picture as you're looking at right here, and that the variance would be at this corner right here. As you look at
maybe
B, we're looking into what would be where the mudroom would be. So we're essentially bringing this wall out to the edge of the window that you're looking at right here. It's a very small addition, but when we do that, because of the angle that you have on the side yard that you're looking at right here, when that corner comes out, there's going to be that 5-foot incursion into the building setback line. As you look at C, this is the C and D. We're looking, or actually C, we're looking to show that the existing rear of the home, where we'll be doing the box out of the addition on the other side of the house, is all impervious cover right now, so we're not doing any additional impervious. Once again, this is looking at in D, you're looking at where the mudroom would be added on from the wall coming out essentially to this window right here. This is E and F. You're looking into what is now a cutout into the house, and we're just going to box out this corner. Basically, as you look at G also, this wall and the wall coming from the current 1-story addition would be squared off.
Now I'm going to show you what I've marked as A5A, which is a Google aerial of your property, and then give me a minute to hand them to the board, and then you can just describe where your house is and where your neighboring homes are.
Correct.
Okay, Steve, go ahead. So good.
So we're right here where you see the 333 Chamonix Road and the marking. Chamonix Road comes basically as you look up in the outside of the picture.
Watch yourself, Pat.
Heads up, Pat.
Come.
Yeah, there you go.
Okay.
So Chamonix Road comes down. This is Fairview Road back in here. Chamonix Road comes up. This is Aberdeen that would come in here and comes around like that. So our house is here. Everyone's got 1+ acre zoning here. So the closest house and where the variance would be, this would be a little addition we'd be putting on. This house is over 300 feet away. This house is over 300 feet away. There's certainly no effect to any of the other surrounding homes that you have around there.
The structure that's proximate to your home, that's your garage?
Yes.
Okay.
That's a compliant garage.
Right.
I'm going to show you what I've marked as A6, which is also a new exhibit, and if you can, let me hand it up to the board, and you can tell the board what that represents.
You have A7, the existing structure, too. Do you have the existing structure, too?
I don't know. Go ahead.
Okay.
Just tell them what you're
Yeah,
doing.
so as you look at the A6, this is essentially the same floor plan that we have, let's see, this is the existing floor plan that you're looking at right now that you would see. So all we're going to be doing is we're going to box out this corner over here. That's to the right as you're looking at it. And then this existing room, we're going to pull this a wall about 4 feet down to create 4 to 6 feet down to create this mud room that we have in here. And once again, because of the angle of this line right here and here, it's a kind of an odd-shaped lot. We're going to have this triangular piece that it will be coming into the side yard setback, and that's the.
So in
that's for
effect,
the,
as we said, it's indicated on A6, you're just squaring off what is the existing line of the home.
Correct. And going back towards, the hardship argument, there's nowhere else we can do it. This is the only place we can recreate a mudroom.
Nick, did you handle the advertising, the stuff went
Yeah,
out?
Steve did, I think, actually.
Yeah, and we got certification. We had to send out 99 notices, believe it or not, primarily, I think, because of this extension we had here. But we provided certification to the zoning
Is there
secretary.
anyone here in the audience who wants to speak to this matter? Okay. Do any members of the board have questions for the applicant or their counsel? I would suggest in soliciting a motion that even perhaps more clearly than the last matter, this is de minimis. This is essentially we're talking, what, about 25 square feet? So, that being said, anybody want to make a motion?
Bill, I'm sorry, may I request the exhibits to be part of the record?
Exhibits are part of the record, thank you. Anyone like to make a motion?
Mr. Chairman, I move that the applicant be granted the relief they are requesting on the basis that the relief constitutes a de minimis variance under the code.
Is there a second to that motion?
A second.
Just a quick, there's no need to make further clear that this is just tied to the plans that's set here. Right? I mean, just, you'll make sure that it's.
I'm sorry,
The order will make clear that it's tied back to the plans as presented.
Oh, yeah, of
Yes,
course, yes.
yeah. Okay. Motion made and seconded to approve the request for variance. All those in favor say aye.
Aye.
Aye. None opposed, 5-0. Good luck with your project.
Thank you, guys. Have a nice evening.
Nick, Nick, can you help out court reporter with a couple of We're going to take a break and start at 8:20. Okay, we'll bring this back into session. The final item on our agenda, Appeal 3000. The applicant, 157-159 Garrett Avenue, property located at 157-159 Garrett Avenue and zoned Garrett Hill-CR, seeks a modification of the zoning hearing board appeal 2575. Applicant requests removal of the board's condition which states, quote, "In order to reduce noise emanating from the subject premises, the windows of the subject premises shall be kept closed at all times when the new restaurant is open for business," close quote. Counsel.
Good evening, Jamie Junn here on behalf of 157 Garrett Avenue LP, which is owner of the property at 157 and 159 Garrett Avenue. The premises is currently occupied by Garrett Hill Ale House. We are here today because in 2003, in connection with a parking variance that was granted, there was a condition imposed by this board that the windows at the establishment not be open during business hours. There were, I believe, 4 other conditions also imposed. We're currently in compliance with all 5 conditions. We're just seeking a modification of the 1 condition with respect to the windows. During break, I handed out the exhibit package, and I'll quickly just go through what's in the exhibit package before I introduce my one and only witness, Angie Mitchell. Exhibit A1 is just an area of the property. In the center of the sheet, it says 157 Garrett Avenue. There were photos, which were marked Exhibit A2, that were submitted with the zoning application. And it basically shows that all of the establishments that are immediately adjacent to the building are commercial. Exhibit A3 is a new exhibit, and there are various photos of the windows from Garrett Avenue as well as from Conestoga Road. It basically shows you what the windows look like closed and what the windows would look like if they were permitted to be opened, and also shows you an inside view of what the windows would look like open. Exhibit A4 is the prior zoning decision and appeal number 2575, and that's where the condition comes from. Again, this was in 2003. Just to give you a little bit of a background, at that time, there was the Brick Bar that was at this establishment, at this property, and there was a lot of concern because it had been considered a nuisance bar. There was concern with noise, with it mainly catered to young adults, so it was a lot of students that were coming from the colleges and the student housing. So there was concern with the noise related to them, leaving at 2 o'clock and meandering throughout the neighborhoods as they're walking back to their colleges or to their dorms. So as a protection against that, there were conditions that were imposed, but what Angie will show through her testimony is that there has been a change in circumstance since 2003. Basically, the change in use and the type of restaurant that's located there now that warrants a modification of that condition. Exhibit A5 is an incident report for the last 2 years, and that's how long the current establishment has been there, so that's what I requested from the township. There have been no incidents related to noise. All of the reports are relating to, I believe there was a car accident, there was an illness of someone where the police was called out. I think there were a couple instances of there was one instance of a boot being put on, and a couple instances where there were vehicles that were towed. So again, there was nothing related to noise. Exhibit A6 is our 2 letters that were written by nearby residents in support of the application, considering the time of day and not knowing when we were going to get called. It was a little hard to have people actually show up in person, but they did. They were nice enough to provide written statements. Exhibit A7 is also a petition that was signed by various residents, and what I've done is I've highlighted in yellow all of those residences that appear on the last sheet of the exhibit, and it basically shows you who these people who signed the petitions are living in relation to the business. The business is highlighted in pink. So that's all of my exhibits. And I'd like to call my first witness, Angie, if she can be sworn in.
Angie Mitchell.
Please use the mic.
Angie Mitchell.
Could you please state your address for the record?
Yes, I live at 632 Overhill Road in Ardmore, Pennsylvania.
And are you familiar with the daily operation of the restaurant?
I am. I run them daily.
And how long have you owned the restaurant?
We have owned the restaurant since 2011.
Can you please describe the type of restaurant that's operating there now and the type of patrons you have?
The Garrett Hill Ale House, we call ourselves a comfort fine dining, casual fine dining. We cater to a broad range of groups, mostly at average age, I would say 40 to 70. A lot of professionals, a lot of university professors, faculty, a lot of people from the law school. It's a diverse group that is more of a professional audience.
And could you just explain to the board what type of menu items you have?
So we call it, like I said, gourmet comfort food. We have probably the best chef on the main line. We do average entrees of 22 to 27, moderately priced, sandwiches, things for children, mostly casual comfort fare that's good for dinner.
And can you explain to the board what led you to file this zoning application?
Yes. So, like I said, we opened in 2011, and when we opened, we did some minor renovations to the interior. We fixed equipment. We pretty much purchased a property that was very worn down. So we focused our focus on the interior. Over the summer, we decided we were doing some repairs on the outside and noticed that there was some separation of our windows in the facility. At that time, we had to make a decision to either fix the windows or replace them. We decided that it'd be a nice amenity for the restaurant to have windows that actually open and allow some fresh air to get in. So we had them replaced.
But that's also when you found out that there was a restriction that prohibited you from opening the windows during business hours, correct?
Yes, correct. I was not aware that there was a restriction on this address to not have windows that could open. And I found out when we were putting them in.
And if permitted, when would the windows typically be open?
Just during nice days and mostly just up until dinner, so until 10 o'clock. And we're only open for dinner. So during the summer, the spring, when it's nice outside, when air's not necessary, and sit inside to open them and allow fresh air in.
Quick question, clarification. What are the hours of your business?
Yes, okay, so Monday through Friday, we're open from 4:30 p.m. to 2 a.m. On Saturday, we open for lunch at 11:30, and we're open till 2 a.m. And on Sunday, we open for a Sunday brunch at 10 a.m. and close at midnight. On all days, though, my kitchen closes at 10 p.m., just for the record.
Thank you.
And in your opinion, has there been a change in circumstance since 2003 that makes the condition no longer necessary?
I do. I think the change in circumstance is definitely the type of establishment and the manner in which it's operated. We're not what was there in 2003. We're not an organization that was forced to renovate to save their liquor license. We're an establishment that are very reputable. Like we've been there since 2011, have 0 citations. I have no marks on my liquor license. We're community people, and we care about what we have in that facility. That is definitely different than it was in 2003, and I think a lot of things have changed since then. I mean, restaurants alone have a lot to compete with. In 2003, you couldn't have outside dining. We were allowed to smoke in a bar. All those things have changed now. So it makes restaurant owners forced to compete for business and find out what's important to people, which is part of the point of our petition. We wanted to find out what's important to people, who's opposed to it, why are they opposed to it, and let's talk about it. Because my job is to create a facility with amenities that attract. I mean, windows that open should be just as necessary as Wi-Fi in a restaurant. That's my opinion.
Okay. And in your opinion, if the condition was modified, do you believe that there would be adverse impact on public health, safety, or welfare?
Absolutely not. I think it would actually encourage people to dine out in their community and want to stay local rather than go to Wayne or downtown Bryn Mawr, where all of these amenities are currently allowed and take place.
And you've touched on this, but have you spoken to your neighbors about the proposed modification?
I have. I have spoken to every neighbor that has come in the restaurant. There are a lot of locations immediately adjacent that are student zoned. We're not a student popular restaurant. My price point doesn't appeal to them, and I didn't really feel that their support meant as much as the local community, the older crowd that come there every day and dine with us.
And that's all of my questions for Angie.
Members of the board, do you have questions?
Just a quick question. The petition that has been included in the materials, can you tell me a little bit about how that was prepared and how the signatures were gathered?
Oh, yes, so we only did this in the restaurant. So I put together the petition and asked people when they came in, I gave them a copy of the application for my appeal and asked if they had any interest in supporting it. That's all the way I obtained signatures. I did not go door to door. I just let people come in and try to support it.
So you have no way of knowing whether the information that's on here is accurate as it's reflected, for instance, someone's address or anything like that? I mean, you don't know these people, they just signed the petition and...
I would say 70% of them I do know. They're repeat customers that come in quite often.
Okay, would it surprise you?
I'm going to interrupt you for a second because do we have counsel representing an interested party?
The Township, sir.
Oh, so I'd like to give him a chance to ask
I
questions.
will stop my cross-examination.
I don't want to preempt a member of the board in asking questions. I'm happy to wait if the chair would so desire.
I think I would like to give you an opportunity, put your name on a record, ask questions, and then we'll follow up.
That's fine.
Okay.
For the record, Sean Gresh. From
Please
Grimby and
use the mics for
Very good.
TV purposes.
Sean Gresh from Grimby and Thatcher on behalf of Radnor Township. Ma'am, I was present in the room for your testimony. I just have a couple of questions for you. I'm correct that the kitchen closes at 10 p.m., is that right?
Correct.
Is that every day, 7 days a week?
Yes.
Okay. In your discussion, when your counsel was asking you questions, you talked about what changes there have been. I'm correct in summarizing those that the changes are changes to your clientele and to the nature of the clientele that you wish to serve. Is that right?
As well as the change of type of establishment that we are.
Okay, and when you say type of establishment, you're talking about what is offered, the types of food that are offered, the types of beer that are offered, and the price point that you're charging, correct?
Correct, as well as how we operate. And It's not an operation of a nuisance bar with a college bar atmosphere. It's completely different.
Okay. You would agree with me, though, that certainly since you took over in 2011, and also since since these conditions were imposed on the bar back in 2003, that there hasn't been any physical changes to the property or to the land that would necessitate that. Is that correct?
That's correct.
Okay. And you are, I believe your counsel went over this, but you are compliant with all other conditions?
Correct, yes.
As they're stated in the earlier decision? If I could call your attention to the exhibit that's been placed before you, specifically A1. Actually, it might be easier to show you on, this is A1 here. Now, you've already testified that none of the adjacent properties are residences. Is that correct?
Correct.
But there are several residences within at least 100 to several hundred feet of the bar, isn't there?
Yes.
All right. And you would agree with me that they're also well within earshot of any patrons who might be sitting in the bar with the windows open or standing outside the bar and having a conversation?
If it was that type of an establishment, yes.
Well, I'm not saying that it is or it isn't. I'm just asking that would you agree with me that those residences are close enough that if you and I were having this conversation standing outside of your bar, two people passing in the sidewalk, that you'd probably be able to hear us from at least one of those residences?
Within 100 feet?
Yes.
Yes.
Okay. Am I correct that the bar is air conditioned?
Yes, it is.
And obviously it's heated in the summertime?
That's correct.
All right, so the issue of open windows isn't necessarily a comfort issue in the summer or the winter for your patrons. It's more of an atmosphere you wish to purvey to those patrons, correct?
Correct, yes.
Okay. And would it be your intention, if the board were to grant your relief, that those windows would remain open for the entirety of the hours during which the bar is open?
Not necessarily, no.
Okay, well, when you say not necessarily, You mean sometimes there would be times when your kitchen is closed, but the windows might be open?
No, I mean, I'm trying to be reasonable. I don't want to open the windows beyond when it's needed. I really don't think even in my community, I wouldn't want them open past 10. That to me is quiet time, and I would be willing to agree to that.
Okay. Is the property up for sale?
It is not.
Would you agree with me in looking through the package of photographs introduced or at least described by your counsel? And if I may, I want to show you at least one or two of them. May I, counsel? I'm looking now at A2 and make sure I get the right one. I'm sorry, A3, particularly page 4 of A3. Appears to be a photograph. For reference for the board members, there's what looks like a popcorn machine next to the window in the photograph, if you're trying to find it. Ma'am, I'll show you page 4 of Exhibit A3. That's looks like a French door that was installed in one of the window areas, correct?
That's correct, yes.
And am I correct that the area to the immediate right-hand side of that photograph is actually the bar where patrons would stand and receive beverages?
Yes, that's correct.
Okay. And what street does that door open onto?
That is Garrett Avenue.
Okay. And I'm sorry, that's a sliding door, it's not a French door, correct?
It's a sliding door, yes.
Okay. Would it be the restaurant's intention to use that as a point of egress?
Absolutely not.
Okay.
Does that door have there's essentially a windowsill there?
I think it does, yes.
So it's not as if somebody could walk directly out. They would have to climb over something.
Correct, yes.
And would you agree that on the Garrett Avenue side, there's approximately a 24-inch difference between the bottom of the door and the sidewalk?
I would say yes.
Okay. But you don't intend to have people coming
No.
in and out of that, right?
No.
Okay. Gentlemen, I believe that's all I have for this witness. Thank you.
Thank you. I'm going to return to the board and give Mr. Riley first dibs because I interrupted him if he wants to continue with any questions.
Sorry, Council, are you opposed to this?
Yes, sir.
John, do you have any current questions? Questions from other members of the board?
Yes. Do you currently have outdoor seating at your restaurant?
No, we do not.
And would that be part of your plan, that if you have the windows, that there would be? Is it allowed? I don't even know.
It's not allowed. I wish
Oh,
it
it's
was
not
in Garrett
allowed.
Hill, but it's
So-
not.
Okay, and so the windows are just more for ambiance
Yes.
and anything like that? And I take it that you already have the windows, so it's just a matter of opening them, is that
Yes.
correct? And do the other restaurants in the area have windows? Do you know, the Flippin' Bailey's and I forget the name of the Italian restaurant across from you?
Yes, Flippin' Bailey's does, yes.
They do, and do they open them?
They do, yes.
Okay.
And if I may just clarify for the board, before when the condition was imposed, it used to be a bar where basically everybody stood, and I think they could accommodate up to 200 people. They didn't have a kitchen. They had a very small bathroom. It's been renovated subsequent to that, and currently there's only 66 seats in the establishment. There's 10 along the bar and then 56, throughout the restaurant. So just wanted to clarify that as well.
And do you have live music?
We have an acoustic guy that comes and plays a guitar on Friday night at 10 o'clock.
So that's one bit of music and whatever.
But again, Angie's proposing that after 10, the windows would be closed.
Okay.
Counsel, do you have any additional witnesses that you want to present?
No, this just Angie, and I know Mr. Gresh was kind of getting into what the factors are when you're looking for a modification of a previously imposed condition. And the legal standard is that you have to show a change in circumstance and also that there's no adverse impact on public health, safety, or welfare by modifying the condition. There are different court cases that have looked at looked at what is sufficient change in circumstance. For example, there was one case where the zoning hearing board imposed a condition where a restaurant establishment had to have private pickup of trash and also store all of the trash indoors. And in that case, the court looked at whether there might have been a decrease in the amount of trash in order to lift that condition. There was another case where a restaurant was looking to lift a condition on its hours of operation. And there the court looked at whether there had been a change in the surrounding restaurants and in their hours of operation that justified perhaps a modification of that condition. So it doesn't necessarily have to be a physical condition of the property itself that you show, but as I hope we've shown through Angie's testimony, I believe it could be just a change in the type of use itself that would no longer make that condition appropriate, and that's what we're saying here. We're saying that, we understand the concerns they had in 2003, but over the years, and at least in the last 3 or 4 years that Angie has been involved, there's been no nuisance related to the establishment or noise-related complaints, and we think that that's sufficient change in circumstance. And also, the fact that we were able to have supporters sign a petition that directly said that we will lift the condition, I think that would show that there isn't necessarily an adverse impact on public health, safety, and welfare. And I know we have a couple neighbors who are actually here too as well to provide statements.
Council, I have a couple questions on that since you went back to this petition. I wasn't going back to the petition, but since you did, I will.
Okay.
There are names on here and addresses on here of people that haven't lived at these addresses for several years. Are you aware of that?
That they have not lived at those addresses?
At the addresses that are shown on the petition. Are you aware of that?
And I don't know. I went by just the addresses, so I wouldn't personally know. I do know that Angie does know a lot of them personally, but I don't have that knowledge.
Because I'm trying to see get a sense of whether, how much stock we should put in this.
Sure.
And former neighbors of mine are on here. They haven't lived at the address that's shown on the petition for several years.
Okay.
So what are you handing us here? And let's go with that question first, then we can get to my other question.
Okay.
She's handing you a petition they signed at the restaurant.
Yeah,
They didn't check IDs, I imagine.
No. But
And that goes to my issue of how,
Well, we got to decide how much weight we give to it.
Right, exactly right. We have to weigh what's presented.
Right, and I agree with that. And again, I didn't double check. I don't know that all of them are valid, but we do have 2 letters that are supported, and I believe those 2 people reside at the addresses where that's stated in the letter. That's Exhibit A6. And again, we have people here who have waited that would provide live testimony as to what they think is appropriate.
Okay, now going to the change in circumstance argument that you were making. Are you suggesting to us that to the extent that we were willing to provide relief that's been granted, that we could somehow condition that relief to match the type of business your client runs and nothing else? Because the condition that we're talking about this evening is independent of the type of business that's run out of the premises, correct?
And what we're asking for is a reasonable modification. So if there was a condition placed on the ability to open the windows, we would consider that, and that will probably be acceptable to us. I know, for example, there are situations where, for example, in Lower Merion Township, when they have reserved parking, they they have a covenant that basically says, we don't have to pave the parking spaces until the zoning officer determines that a need is necessary. And at that point, you can either appeal or put the parking spaces in. So I think something like that might be appropriate here if, based on, if the condition is lifted or modified, but it becomes that there is a nuisance in the future, that they would have to come back for another, consideration.
I'm gonna leave that aside, assuming we could do something like that. My concern is the next operator of a business out of this location, not the current operator, the next operator. What's to stop the nuisance from recurring?
And we understand that, and again, I think there's an appropriate condition that could be placed that addresses that. We don't necessarily want to go there, but if there is a concern about a new owner coming in, I mean, the simplest thing to do, I think, would be to place a condition that says once it changes to a different type of establishment, you would have to come back if you wanted to continue that, condition, or if you wanted to open the windows and carry that forward.
Well, that's sort of regulating, ownership.
You need to use a microphone.
I mean, putting aside, the township or the zoning board trying to police it, and the zoning board certainly doesn't have authority to police, that smacks of regulating ownership, which is beyond the purview of this board. At least strikes me that way.
Let's hear the rest of the testimony before we get into that level of detail. Are there other questions, excuse me, are there other questions of this witness at this time? Okay, I'm sure you're not going anywhere. Mr. Gresh, are you putting on witnesses, or do you just want to respond to perhaps comments that may be, how were you envisioning proceeding?
Mr. Chairman, I do not anticipate calling any witnesses. I do know there are several members of the community, I believe, here to give opinions from both sides of the issue. I reserve the right to obviously cross-examine any witnesses and make both legal and factual argument at the appropriate time.
Thank you. Okay, folks, what we will do now is open it up for comments from anyone who would like to comment. Come up, introduce yourself, identify where you live, give us a sense of perhaps the relationship of where you live to the property in question, and tell us what you want to tell us. It's wide open if anybody wants to speak. Now, you're going to be talking to us. You're
That's
not going to
fine.
be talking here.
Hi, my name is Kim Cruz Engelhardt. My name is on that petition. I live at the address that is on that petition.
I'm sorry. You'll need to be sworn in.
Sorry.
Do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
And before you
On the Bible.
you have to restate your name perhaps a little bit slower and spell it for us, so you put it on the
Okay.
record.
It's Kim Cruz, CREWS hyphen Engelhardt, ENGELHARD.
And could you tell us where you live
Sure.
and perhaps orient us to the property in question?
Here.
Is it on the picture also? Or just?
That's what I couldn't figure out. I was trying to orient myself to the picture. No, I'm right here.
Okay.
I'm right here.
All right.
There's the
Okay.
high-speed line right here, and I'm right here.
All right. Thank you.
Okay.
Please share with us what you would like.
Sure. I'm a frequent patron of the Garrett Hill Ale House. I would appreciate the windows being open. There are times when it is a little stuffy, and fresh air in there would be nice. I will say I was in the Brick Bar once when I think it was during the daytime and there were no college students there. It was disgusting, dirty, sticky, revolting. Not a good place to go. The Garrett Hill Ale House, I think, is like the third or fourth owner or restaurant to be in this place. In the 6 years that Angie has been running the place, we've seen a change in the clientele. When they first opened up, there were college students who would bring food from other establishments in there, and they have since, over time, gone away. So now the only college kids who are going in there when we're in there are ones who are on dates or who have brought their parents there, because it is a nice local family restaurant. We bring our kids there. We arrange to meet friends there. We go on Facebook. We see friends from other communities coming to this place to actually frequent the bar. I support having the windows open. I think they should be closed, during township quiet hours. I think that's appropriate. And it's just, we'd like to see this place thrive. So
I'm going to ask you a couple
ahead.
questions that'd be helpful to me. Give me a sense. Do you go once a week, once a month, twice a year? How often would you say?
Okay, you're not my doctor, so this is not going to go on
No,
my medical
no,
forms.
not at all.
We go about 3 or 4 times a month.
Okay. And when
Usually
you-
on a
and-
Friday or Saturday night.
And, okay, that's good. So Friday or Saturday night, would you be 8 o'clock, 10 o'clock, midnight? Give me a sense there.
So,
Or all of them. Maybe go to the 8 and stay till midnight.
so it depends on whether or not our friends show up.
Okay.
We'll start at 5:30.
Okay.
And, you know, when we're ready to leave around 7:30 and our friends start showing up, we may stay till 10.
Okay. I'm asking these questions because I
Go
don't
ahead.
know the property, and you're
Absolutely.
closer to neutral than some of the folks we're talking to.
Yeah, and it's,
If you walked in there on a, what I might describe as a normal Saturday night at 7:30, around how many people are in the establishment?
so, including children, because I will say it really is a family restaurant. I can't tell you the number of times my children as small children have thrown up in that restaurant, so we're not going to hold that against them either. I would say probably around 35, 40. And it's going to be, I will tell you, it's people our age.
All
And
right,
children.
I'm done with my questions. Are other members of the board have any other questions of this witness? Does either council have any questions of this witness?
I have no questions, Mr. Chair. I think it would be a good idea if the witness could initial the location of her property on the
Sure.
map. That way the board, I'm sure, is interested in where each of the witnesses lives in relation to the property. If council doesn't mind an amendment to her.
No.
exhibit.
Okay,
I do have one quick question, if
Sure.
you don't mind. Have you ever been in the establishment past 10 p.m.?
Yes.
How does the establishment change at that time? Like, is it louder? Is it quieter? I mean,
It
'cause I'm
gets
trying to get
emptier.
an idea about the hours limitation.
It gets emptier.
It gets emptier. Okay.
Yeah. The only time I've been there when there have been more than 20 people after 10 o'clock is when we were throwing a birthday party there.
Okay. And when would you say most people tend to stop dining? Like, is it toward 10? Is it earlier?
I'd say it's earlier. I'd say it's
Okay.
closer to 9 o'clock.
Okay.
appreciate you coming out. Thanks for your
Thank
testimony.
you.
I'd like to hear from anyone else in the audience who'd like to share their perspective.
Hello.
Please put your name on the record, and then we'll swear you in.
John Engelhard.
Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Engelhardt, where do you live?
70 Garrett Avenue also. Husband of
Okay.
previous speaker. Basically, just want to reiterate what Kim said. We've lived at 70 Garrett Avenue, which is basically about a block and a half from the ale house since '95. At that time, statistically, I probably would have been more a patron of the Brick Bar, but that place was so nasty, I didn't go there. I mean, it was bad. It was definitely bad. We enjoy the ale house, like Kim, basically most of what Kim said. It's been an addition to the neighborhood. It's been good for the neighborhood. We see friends from neighborhoods this way, neighborhoods this way. You know, Garrett Hill is the center, but there are a lot of surrounding neighborhoods that all have names. And we do see people from around. And it really, it just adds, I mean, outside dining would be phenomenal. Sidewalk dining would be great. We don't have the room and we're not allowed to do it. But the next best thing would definitely be able to just have fresh air and just be sitting kind of in a window. And I will say, as far as noise, we've been across the street where the windows are open. The traffic is louder than the people. I need to throw it out there, too, that Villanova very frequently is louder than anything. Last weekend, all day Saturday, in my home with the windows closed, I could feel the bass.
We're familiar with that circumstance.
In my belly. So, you know, just to kind of put things in perspective. But no, I think the Mitchells have done a phenomenal job with the ale house. It really is a neighborhood establishment. It fits in the neighborhood. And we want them to succeed because we want it to stay there, because we like it. And there are a lot of families there, Friday evening, Saturday evening. Usually by the time we get there, there'd be 6 or 7 maybe families eating dinner with the kids and everything. It's nice to see.
Any questions of this witness? Council, either council have any questions? Thank you for sharing your testimony.
Thank you.
Anyone else?
Okay, do I need to swear in?
State your name,
Okay.
please.
My name is D-E-E, Delaney, D-E-L-A-N-E-Y.
Okay, do you swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Yeah.
I reside at 229 Williams Road, and for those that may not be familiar with the neighborhood, Garrett is on one side, and if you would continue across Conestoga, there's Williams Road. So I live down Williams. Yep.
Is,
And I'm at 229 Williams. So I would say I'm like probably like something like this right here. Can you put your initials on it? Sure.
so it looks like behind the commercial establishment at Conestoga and Williams, there's a couple parking lots, three, either, I guess, if they're twin homes, 6 residences that we're seeing there. And then you're about how much further off the picture?
I would say that I'm approximately halfway between Fitzwilliams and Conestoga Road.
All right, thank you.
And I'm,
Okay.
yep.
What would you like to share with us?
Well, I have a couple of things that to say, and maybe to provide also an overview for anyone that is not familiar with the history of this bar, and I'll try to keep it very succinct. Oh, sorry, succinct and to the point. And just some of these things are just going to be in response to things that I heard about Flippin' Bailey's, which they put in these window walls. And they got permission to have those windows open, I think, until 9 o'clock. And I don't remember ever receiving any sort of notification about that proposal or being invited to provide testimony or anything for that. And I can say that Flippin' Bailey's has had noise disturbances since that's been the case. I know because I've called them in. I think part of the reason that this establishment doesn't have noise disturbances is because of the safeguards that are in place right now. And I think that it's all the more important to keep those safeguards in place, both now and also for future owners, business owners and property owners. Because Flippin' Bailey's has a for sale sign right there, and my understanding is that the folks that own Flippin' Bailey's are the same people that own the Garrett Hill Ale House, and that in the grapevine I've heard that maybe there's some negotiations or discussions going on right now to maybe have a buyer buy both properties together as a package. I don't know if that's true or not, but it does make us feel very vulnerable to what another business owner or property owner might do with those establishments. We are very close to Villanova University. We're within easy walking distance of Villanova University. And they're going to be putting in new sidewalks, which I think is great because those sidewalks that go from Villanova into Bryn Mawr are very dangerous. But it's sort of, and those new sidewalks are supposed to go right up to Garrett Avenue, and it sort of creates a gateway to the community. Now, as far as I would like to just use some of the existing language in this, the original opinion of the Zoning Hearing Board, because I think it brings home to a great degree the what we were living through during that early time of the Brick Bar, and we don't want to go back to anything like that. And so very briefly, I will just in case there's someone here that doesn't know about the history. The findings of fact in the original opinion of the Zoning Hearing Board, they talk about the Brick Bar catering primarily to young adults, concentrated on the sale of alcoholic beverages with little food. It soon became a source of noise and disruption in the neighborhood. That's item 5. Item 6 is many of the patrons of the Brick Bar walked to and from the Brick Bar from colleges and student housing within walking distance of the subject premises. Item 7, among the negative impacts of the Brick Bar and its operations as reflected in the extensive testimony by neighboring residents. And I also know that there were copies of police citations that were presented, stacks of them. Reflected in the extensive testimony by neighboring residents were loud noise into the early morning hours, disruptive crowds, rowdiness, public drunkenness, trespassing, littering, inappropriate behavior, including public urination, and the disruption extended to surrounding residential neighborhoods due to the fact that persons leaving the Brick Bar would wander through such areas late at night and into the early morning hours. Item 8, the layout of the bar, which now has been, I think, remedied by they've put in more seats, which is a good thing.
Ms. Delaney?
Yep.
We do have a copy of
Very
this
good.
as part of the record, the
Okay.
application that was submitted.
Okay. So my feelings are that although we may not have that situation now, we could have it again. The other thing that's happened recently during the summer, 2 bars in Bryn Mawr closed, both Aaron's and Malone's, which were considered college dive bars. And I've seen on college student websites, new students are coming in and they're asking, where do we go? Where do we go to have a good time? Where do we go to party? And so students are actively looking for new places to go to. I think that the safeguards that were put in place by the original zoning hearing board were meant there to protect us, not just now, but also into the future. And I've lived in Garrett Hill for 20 years. And it took us years, once things got out of hand, it took us years to finally get the safeguards in place that we needed. And now I can't tell you how great it is. I've gone to the Garrett Hill Ale House. I enjoy it. My spouse has as well. We've met groups there. There's no question. It's a great place to go and to eat and dine. Our objection is to keep the windows closed. That's all. The windows don't need to be open. I never once, while I was sitting there enjoying the conviviality of meeting neighbors and other people, I never once thought, God, wouldn't it be great if the windows were open? I never thought that. It didn't even occur to me. So the real necessity for opening these windows and then exposing us, and I can tell you, the noise travels right down Williams Road. I know what's going on all the time. And Flippin' Bailey's, they have Quizno night and stuff like that, and it's gotten very loud, just with a small window upstairs of Flippin' Bailey's. I could hear it inside with my windows closed. And I went outside to see what it was, and that was one of the disturbances that I closed. The Garrett Ale House advertises that, and this is from their website from yesterday, a beer quizzo every Tuesday at the Ale House. Join us every Tuesday night for beer quizzo. Throw down your beer, hot topics for great prizes, bragging rights. Sign up starts at 8:30. Questions start at 9 p.m. Come early for a delicious dinner. Stay for the trivia throwdown and beer specials. They also advertise for live music. So I would just say that our neighborhood is great. We've got this great new park. We're very happy with the way things are, and it would be very important to us to maintain that.
First, a technical question.
Yes.
I will be asking you
Yes.
and anyone else who testifies. For purposes of clarifying the record so that there's no confusion.
Yes.
Are you opposed to this application?
I am.
Okay.
Oh, I'm
That
so
has to
sorry.
that has to do with
Yeah.
clarity to whether they'd be standing to appeal.
Okay.
Relax for a second, don't run away.
Okay.
Counsel, any questions? Okay. You'll have a chance to share closing, don't leave just yet.
I'm not leaving.
Counsel, any questions?
Yes, thank you. Ms. Delaney, are you familiar, do you know whether there's any student housing within the vicinity around the bar?
Oh, there's a lot of student housing. Excuse me. There's a lot of student housing on Garrett Avenue. Do I know how many?
How far away would you say the student housing is from the bar?
It's right across the street.
That's all I have, thank you.
Any questions from members of the board?
I do.
Bud, go ahead first.
You've lived there for 20 years,
I
is
have.
that correct? So
Yes.
you were there during the time that this brick bar was there?
I was there before, and before it got bad, and then when it got bad.
And did they have open windows at the time?
Do you know the Brick Bar, nor Flippin' Bailey's had these big windows before?
Well, but did they have open windows at the time that they were such a nuisance to the neighborhood?
I don't remember. I know that there were massive congregations of.
But did they have open, I guess
don't
my
know.
point is
I don't
that,
know.
is the nuisance related for the Rick Bar to the fact that they had open windows or closed windows? Or was their nuisance was just that the bar was poorly run and it didn't matter what the windows were?
Well, I can speak to the nuisance noise that came from the open doors, which were.
Well, I'm
at
asking
that-
about the
yeah.
windows. Did
I
they
think- I
have
think
open
the
windows?
witness has indicated she doesn't know whether there were
Yeah.
open windows.
Okay. Well,
And
maybe we'll find that out
Yeah.
then as we go through, because I guess what my point is, I share your concerns about not having a nuisance bar, but the concern I have is that nuisance really related to the way these people run their business and what they're doing, or is it related to open windows? Because, people just have open windows and the bar, or not necessarily bar, but the restaurant is run properly, then it's
Mr.
fine.
Hirsch, that may be a point to make in discussion within the board, but we're not going to
Yeah.
have,
mhm.
I don't think we need to have
That's
debate
fine.
debate with the witnesses. Are there other questions?
Yeah, very quick question.
Yes.
Would you also theoretically oppose the application if there were a limitation to having the windows open only until 8 p.m.? So only dinner hours, and then, so no quizzo hours, no music hours. They would only be open when people are dining?
Well, let me ask you, are you saying this with the proviso that it's only attached to a certain business, or just for any business to be open until?
I mean, I don't know what limitations will be
Yeah.
tied to this, but, so I can't speak to
Yeah.
that question, but on the idea that it's a business that serves meals, not just a bar.
Right.
So a certain percentage of sales from alcohol, something like that. Would you be supportive of that, if it included that limitation?
Well, honestly, I would rather the windows stay closed because I know how noise travels down our street. I know it from the windows being open at the Flippin' Bailey's. And I know that the people that live in our community are both elderly and young families with children that go to bed at 9 o'clock at night, and they're getting ready for going to bed at 9 o'clock. So,
Any other questions from members of the board? Thank you very much for your
thank you,
testimony.
thank you.
Are there other individuals here who would like to be heard?
Hi, my name is Lauren Wiegand, Lauren Weigand. I live at 229 Williams Road also.
Raise your right hand, please. Do you swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, thank you. I love Garrett Hill Ale House. I go there several times a month. I meet my friends Patty and Rick Barker there, John Fisher and his wife. And the food is great, and it's a fun place. And I can say I'm an RN, and I'm also on the Garrett Hill Coalition. I'm the treasurer for the Garrett Hill Coalition. When we're in the ale house, it can get loud. I'm older. I won't tell you how old I am, but I'm retired. And I can get very loud myself. I was an ER nurse for 15 years at a hospital in North Philadelphia. So I'm very happy with the windows closed. So I'm opposed to having the windows open at any time because I don't want to discriminate against any owners, any future owners, any current owners. I wanted to answer your question about, or someone's question about the windows being open at the Brick Bar. I would come home from my shift at 11:30 at night, and the windows in the Brick Bar were closed. The doors, however, were open. And the door was not on Conestoga at the time. The door was on Garrett Avenue. One of the provisions that the zoning board made was that the door would be changed from Garrett Avenue to Conestoga Road with an entryway to act as a buffer for any noise or potential noise that would come from, there was another owner before Ms. Mitchell. And so that entryway would act as a buffer. We have no buffers. We don't have any bushes that you could put up to surround the bar. It's all brick and mortar. So consequently, noise does come down. And I'm one of the noisemakers. So I guess that's all I have to say.
Please stay for a second.
Yes.
Just for clarity on the record, while you mentioned the Garrett Hill Coalition, you're not here on behalf
I am not
of
here
them.
to represent the
Fine.
Garrett Hill Coalition.
Thank you. Wanted to make sure that was clear on the record. Any questions? Questions?
Ma'am, could you just initial?
Please step up so that.
I'm sorry. Ma'am, on the map that's marked, that's here in front of us, could you just initial where your address is?
Yes.
Thank you. With that, I have nothing further.
Any questions from members of the board? Seeing none, thank you very much for your testimony. Other folks in the audience who would like to be heard on this question? And just to clarify, once we stop getting public input, we stop getting public input. So when it stops, we stop. You can't in a few minutes say, I've changed my mind. Last call, anybody else want to be heard? Seeing none, I'm going to, Solicitor, I'll ask a technical ruling. Mr. Solicitor,
Yes.
do you think it's significant who I should allow to summarize first and last?
I would think that the applicant should go forward, followed by the township, with the applicant having a brief right of reply.
What the solicitor said.
Thank you. I just want to say, I think the testimony of the neighbors who are protesting, it supports our argument that there has, in fact, been a change in circumstance. I went through the testimony of, the transcript of the testimony in 2003 when they imposed the condition, and it kind of goes to your question about what exactly was the nuisance. And I think there was a lot of discussion, again, about the drunk people walking through the neighborhoods, them being noisy outside of the restaurant. I think there was maybe, public urination, that type of thing. So here, and I wasn't quite sure in 2003 why they imposed the condition, because there wasn't that much testimony related to noise emanating from the restaurant. I think it's just one of those things where the applicant figured we'll make some concessions with the neighbors and hopefully we'll get the parking variance that we need. But again, it's been 14 years since that condition's been imposed, and we're just asking for a reasonable modification. I mean, we're not even asking for a blanket removal of the condition. If the board would like to put additional safeguards, but again, I think it would be reasonable for a reconsideration, considering that the circumstances have changed.
Thank you.
Gentlemen, one of the arguments that was purported by, or put forward by the applicant's counsel is evident in the packet that you all received, and that is that there have been no noise complaints. I submit to you that that's proof of the futility of their position. There have been no noise complaints because the owner does a good job. I think everybody here that's testified before you tonight would tell you that this is a great place to go. They have good food, they have good drink, they clean the place up, they have generally a good clientele. I don't think anybody's disputing that. And I think that it's genuinely run with one eye on the restrictions that were previously put in place in 2003. That's why this packet has no noise complaints in it, because when they're open at night, the windows are closed. The people inside are dining, they're drinking, they're having a good time. This is a facility, a business that I'm sure that all the residents of Radnor Township are proud to have in the township. But the requested relief simply has not been made out on the record tonight. The case law is clear, and I'll only give you two cases. I'm sure your solicitor and probably many of you gentlemen are already aware of them. The first being Ford versus Zoning Hearing Board of Cavern Township. That is 616 Atlantic 2nd, 1089. I have a copy for the board and for council, if you'd like.
Please.
And the second case I'll point out to you, gentlemen, is German versus Zoning Hearing Board of Adjustment. That's a more recent case from 2012, 41 Atlantic 3rd, 947.
Thank you.
I believe one of these cases was actually referred to generally by applicant's attorney earlier on, as it does have to do with conditions placed on a restaurant and what the eventual potential compromises were. However, the law in this matter is clear. An owner which wishes to obtain modification of a condition which has become final must establish that circumstances have changed, circumstances running with the land have changed, that render the condition inappropriate and an absence of injury to the public interest. Now, I'll note for all of you that it is assumed under Pennsylvania law that if the zoning hearing board places a condition on a variance, it is assumed by law that those conditions were done in the public interest. So I submit to you that the conditions you're asking to modify, or you're being asked to modify, were in fact done specifically with the public interest in mind. And the burden of overturning them is that it would now be in the public interest to no longer have those conditions. And I'll submit to you that that simply cannot be done in this case. You've heard people from both sides. Some say it's not that loud. Others say they can hear the noise quite clearly coming down the street from those areas and from the bar just right across the street. The reason why you're not hearing noise from the establishment that's before you tonight is because of the conditions that have been in place for the last 14 years. It's the township's, that's among the township's reasons for opposing this request, and we would ask that you deny the requested relief. However, if you are inclined to grant the relief, we are in agreement with the suggestions of many members of the board and of opposing counsel that it can and should be limited. I do agree with Solicitor Ryan that to put a blanket requirement on any condition that it be revisited if and when the bar is sold would be inappropriate for the board to do. I don't think that you could legally do that. But I do think that you could mandate very specifically and very strictly, if you chose to, when the windows would have to be closed. And I believe Board Member Homick suggested 8 p.m. I've heard others suggest 10 p.m. I do believe a strong or a firm restriction on that, if you're inclined to grant this petition, would be appropriate. Thank you for your time.
Counsel, before you step down, your reference to the decision, circumstances, you use the phrase circumstances running with the land.
Yes.
And my question is, were you quoting the decision? Is that the phrase in the decision?
I'll state to you, let me read it right from the decision so I'm not losing it. This is from Ford versus Zoning Hearing Board, 616 Atlantic 2nd, 1089. The specific page reference is at page 1092, Mr. Ryan, if you're looking for that in the opinion. And it notes, it talks about two other cases, namely the gazebo case and the Amico case. I believe I have the Amico case with me if you'd like a copy of that. But quoting now from Ford, it says, in gazebo, the court noted the Amico court's conclusion that landowners seeking to remove conditions must establish that there has been a subsequent substantial change in the circumstances incident to the land itself.
And that's a Commonwealth Court decision?
That's Ford versus Zoning Hearing Board. It's from the Commonwealth Court. Yes, sir.
Thank you, sir.
And I believe, just for sake of clarity, if you wish to review it, because it is being discussed, I do have a copy of Amico versus Zoning Hearing Board of Middletown Township. The site on that is 463 Atlantic 2nd, 103. That's also a Commonwealth Court case. And I'll hand a copy of that to Mr. Ryan as well.
Thank you. Thank you very much. Council, any rebuttal?
I will also hand in a couple cases. I have Emery versus City of Philadelphia Zoning Board of Adjustment and the Dumont Brothers and versus Ross Township Zoning Hearing Board. The standard that's put out in the cases is a little bit different depending on what case you read. And in the particular case that I'm referring to, it says that an owner that wishes to obtain a modification of a condition which has become final, may obtain relief if he establishes either grounds for a traditional variance or change in circumstances which render the condition inappropriate and absence of injury to the public interest. So the wording there is a little bit different. They don't talk about particular to the land or.
And the decision you've just read for us, that is from what, is that a Commonwealth or is that?
This is a Commonwealth decision in 2013.
Thank you.
But I do want to note that it is a not reported opinion, but it is a Commonwealth decision.
But even with this, the burden would still rest with the applicant to show these, that the change in circumstances and that the condition was no longer required to protect the public interest.
Correct.
Anything else you want to share with us?
And I just want to say that, I believe we meet that. I think that there have been some concerns, but again, I think it's general concerns about different establishments in the area. Again, we haven't heard anything about our particular establishment, and I don't think that there has been shown that there would be an adverse impact because of the lifting of the condition.
Thank you. Okay, so at this point, we have completed taking evidence on this appeal. And prior to soliciting a motion, I'm going to open it up to board members to share perspectives, considerations, concerns.
I guess a couple things. I was looking through the previous ruling, and that was a request for a variance on a parking parking spots. And the previous board granted that relief and added a whole bunch of conditions. And the condition about keeping the windows closed certainly to me seems specific to that owner at that time and the use of that property at that time. It wasn't incident to the land or the property itself. I mean, if it was a flower shop, it probably wouldn't have been added. So I don't know how you can look at it any other way. That previous condition was put on there for a specific circumstance, looking at a specific owner, a specific use, and they were trying to deal with a problem. So now we're asked to reconsider that condition, and this is not a zoning law that applies to everybody across the board. It was a condition put on a specific owner for a specific use. So if there's different circumstances, and in fact, this is the law, right? If there's different circumstances, and there are different circumstances in my opinion, then we have all the right to remove that condition because it's no longer necessary. And I think the requirements under the law that we heard from both counsel kind of supports that view.
Well, I mean, I think it's clear we have a right to remove it. The one perspective we have to think about is that the decision to remove is essentially a two-pronged test. It's a change in circumstance, and we've discussed whether the change in circumstances is something peculiar to the land or not. And it's also whether the removal of the condition would have an adverse impact on the health, safety, welfare of the community. So part of the analysis, again, it's a two-pronged analysis, and while it's sort of peculiar that the restriction was associated with a original zoning request having to do with parking, and I wasn't there, and I've only read the opinion like everyone else, I think it's fair to presume that part of the analysis back then was if they were going to grant a variance to allow this enterprise to operate at that location, that they needed to do something to make sure that the operation would not be adverse to the health, safety, welfare. And so it was, I don't think it was either gratuitous or haphazard to have such a restriction at the time. And, you know, we clearly have the authority, we have the authority to take it off, and we also have the authority and perhaps the basis to leave it on.
And I think one of my points is it was based on the circumstances in 2003. That's what it was based on. And is it still relevant today? And I think I've heard testimony tonight that the circumstances have changed. The ownership of the current facility doesn't appear to have those same issues. And I also think that, you know, we heard testimony that every business on that corner in that area can open their windows. You know, what's
Well,
what's the
I
significance?
think from my own familiarity, there's 4 businesses on there. There is a food enterprise on one corner which closes at 7 o'clock at night, which doesn't have windows. There's the enterprise we're discussing here. There's a bar across the corner that has windows. And on the 4th corner, I believe it's either a gas station or car repair, which by definition has no windows. You know, it is what it is during the day. So I think your point is well taken as to the one across the street. John?
Yeah, I guess clearly we have the ability to modify or remove the restriction. What I struggle with, and perhaps others here do, is we do not then have the ability to reapply the condition if things go badly going forward. And a relaxed or removed restriction will be in place into the future until someone happens to need a zoning variance and we come up with another restriction at that time. So, I took note of the observation that was made by counsel for the township that, there have not been noise complaints, more than likely because of the existence of this restriction and in combination with a change in the use of the property. But we can't guarantee that will be a similar use in perpetuity. And as we go through the process of considering the modification or removal of this restriction, I think we do need to be mindful of the fact that just as circumstances have changed since the time of that initial opinion, circumstances could change in the future as well.
Well, under that analysis, you could never, ever lift a condition because you can't tell what's going to happen in the future. I don't think that is relevant to the argument. I think the test is if circumstances change. If you think circumstances changed, then you can remove it. The idea that there might be a troublemaker in there 10 years from now, I don't see how we can consider that.
As the chairman has pointed out, it's a two-pronged test, change of circumstance and the removal of the restriction not being injurious to the public health, safety, and welfare. And if somebody can point me to how I'm supposed to analyze that, I'm more than willing to analyze the issue in conformity with something like that. But one of the issues that plays into the the health, safety, and welfare of the community, in my view, could very well be the fact that this relaxed set of restrictions applies not only to the current proprietor of the business at the premises, but to future operators of a business, perhaps a bar and restaurant at that location. And yeah, until somebody tells me I can't think about that in analyzing all of the issues, it's something that I'm thinking about.
If the current owner was a flower shop, let's say, you would not grant the relief because 10 years from now, it might be a rowdy bar.
They have a liquor license. There's a liquor license at the property.
I'm-
The better assumption is there's always going to be a liquor use at that property.
It certainly isn't.
Yeah, I'd like to just add that I think that the restrictions that were put on it at the time were probably appropriate to keep that organization on a tight leash, and I think they were successful, and for that I think everybody's grateful. But I do think that the restaurant scene has changed, and that in order to be successful, I think that we have to listen to people who are in the business that say what they need to be successful. And if what they're asking for is reasonable, I think it's important. And I think the good example that we have in our community is the renaissance of the restaurants on Wayne Avenue, that the outdoor seating, the outdoor places, the things that are going on, that the ambiance that's created, that people like fresh air, they like being able to talk, and that the noise that comes from this, I think is, certainly with the 10 o'clock restriction, would be a great compromise, because I think the worst thing in the world is for us to keep this in there, a restaurant goes dark, and somebody comes along that needs to turn it into a rowdy bar in order to make it successful with closed windows. It doesn't make sense to make it harder for a good restaurant to operate, whereas a lousy one could be successful there.
But I appreciate the West Wayne Avenue, or the North Wayne Avenue argument, but there aren't any single-family or twin homes within 100 feet of those places on North Wayne Avenue.
There's plenty of apartments, plenty.
Maybe some
Up and down.
There may be some apartments, but I think, I am particularly sensitive to the idea that this is not like some parts of Radnor where homes are significantly spread out. These places are right there. You can not hit a golf ball. You can throw a baseball from some of these homes to the front of this establishment.
But I guess my counter-argument to that is that this is zoned commercial. So this is a commercial area, and with commercial uses, that they need to be able to be operated in a manner that they can be successful, and the world has changed. And so I just think that when you're in that kind of neighborhood, it's commercial. We're not changing residential to commercial. It's been commercial. They have a terrific operator who wants to continue there, who wants to succeed. And, what she's asking for, I think, is something that any reasonable restaurant would like to have.
And I'd like to kind of shift slightly to something I brought up with the hours limitation. I don't know that the question I asked about the 8 p.m. Was not my endorsement of it. I actually have a concern that during other hours, there could be noise. If there's someone elderly or who otherwise doesn't work during the day, I'm thinking of St. Patty's Day or something like that. It could be quite loud. So I don't know that the hours limitation would resolve the public health, safety, and welfare issue in my mind. I naturally want to look for compromise, but I'm not sure that that would obviate the concern there.
I'm going to hold for a second to see if there's any more comment or debate before I ask for a a motion. Would anyone like to make a motion?
I'll make a motion to approve the application as granted, or to grant the application.
Is there a second to that?
I second it.
All right, now we're going to debate that. I'm opposed to your motion. I think there's significant concerns here, and I think that there have been a couple potential solutions, which I'm not saying would convince me, but I think would at least serve some purpose. One is a time limit.
If you want to add an amendment?
Not particularly if you think that suggests a moral commitment to vote with you. And the other question,
Immoral.
and the other question, which I would ask for the solicitor, is I remember a circumstance in Garrett Hill within the last couple of years where something was granted with a time limitation.
Yes.
So that is within our authority?
It is within your authority.
John, your mic.
It is within your authority, but it does get into township, more proceedings and. Okay. How's that? All right, there we go. We did that, although well, I think legally you can do that. There are issues attendant to policing in the future and people coming back. I think that the one case where we did it, the property had a lot of problems, and I think there was a desire to help them out as opposed to there is a successful business there now. But yes, you could do it.
So the point I will make is I'm opposed to this, but if there are three people who are supportive of it, I would hope they would consider a time limit in terms of into the evening when the windows could be open, and also a temporal limit to the removal of the condition for two purposes. One, to be responsive to concerns of a change in ownership, and number two, if the three people who decide that it should be granted have misread the circumstance, it becomes more disruptive than perhaps they anticipated, there would be an opportunity to relook at it at a stated point.
I would amend my proposal to add a 10 o'clock limit on the open windows, 10 o'clock p.m. I don't want to get into policing this thing.
The motion has been amended. Is there a second to the amended motion?
I second.
Okay, so the motion we're now going to discuss is a motion to provide relief to the condition, to restate the condition, to say that windows shall be closed at 10 p.m. I'm not going to beat a dead horse. I'm opposed. I believe that I am persuaded that while a good operation exists here, that the interest of the neighborhood and its health, safety, and welfare argue in support of maintaining the existing limitation.
And I agree that it doesn't go far enough. The 10 p.m. Is too late.
So we have that motion on the table. We will vote on that motion. All those in favor of the motion on the table say aye.
Aye.
All those opposed, nay.
Nay.
Did I hear a vote from the end? Are you abstaining, or are you asking for more time to make your decision?
I'll vote to oppose the motion as it's currently crafted.
Okay, so that motion has been rejected. There's no motion on the table. I will allow, we'll stop for a second to see if anybody wants to share a perspective in advance of soliciting another motion.
I don't know that that was aimed at me, but I have a thought. I don't want to micromanage people's business, but I want to also be sensitive to the fact that the prior condition appears to have done exactly what it was designed to do and what the neighborhood expected the limitation to do, among the other limitations that were in the prior order. So in crafting relief along the lines of giving the current operator some flexibility to operate the business, yet being sensitive to the community, I'm wondering if an earlier close the window condition is something that we could get 3 votes on, and I'm suggesting 9 o'clock, because if one were to project into the future, can bars get loud at 9 o'clock at night? Sure they can. But my concern, again, looks a little bit into the future, George, and I know that, that's perhaps not seen as the way we should look at it, but it's what I'm struggling with. If the operation of the facility changes and it becomes something that it's not today and something closer to what it used to be in the past, then I look at the issue of, okay, if they have to shut the windows at 9, is a college bar louder at 9 o'clock or 10 o'clock? Some would suggest there's no material difference, and I understand that if it's the type of bar that some of us may have been in from time to time. But they tend to get louder later as they go a bit later into the evening. So I think I can get behind a motion that places a 9 o'clock limitation on the ability to have the windows open. It's my sense from testimony that that's, the dining portion of the evening is tailing off at that particular time. So I don't know that it's going to materially negatively impact the current operation of the facility. Plus, it addresses some of the concerns I have for years out if instead of this facility, there's another operator and another set of facts and something that we're not all expecting. So I would make a motion to grant the
One second. We're not open to motions just yet.
Sorry.
Understanding what you just said, I guess my thought is if you project this, there's 9 o'clock limit, and there is a different operator. The problem's going to be the different operator. If we're presuming that there's some challenges, then because things aren't as black and white, there's going to be, are they open, are they not open, are they closed at 9:15, are they closed at 9:30? So I get back again to thinking that it's an advisable idea if the relief is going to be granted to do something temporary, so that if that relief is granted and things are as hunky-dory as we all hope it's going to be, they come in after a stated period of time, either then ask for a further extension or to have it be lifted. There won't be anybody objecting because it's going to be no problem, and then you're fine. But if they're either, again, if there is either a different operator or there is evidence that it's causing problems to the neighborhood, it would be, and I know we don't do this, we've only done it once previously in the several years I've been on the board, but I think this is, if not a unique case, a special case where it's worth consideration. So with that, I'm going to solicit a motion.
Mr. Chairman, I move that the applicant be granted the relief requested with the following changes. First, the current restriction shall be shall be revised to provide that the windows of the operation are permitted to be open until 9 p.m. And secondly, the relaxation of the limitation shall continue for a period of 3 years. at which time should the applicant or the operator of a facility, or excuse me, a business at the premises wish to continue to have the ability to have the windows open until 9 p.m., they will need to come back to the board and request continuing relief. Phone?
Is your 3-year motion 3 years from today, so that it would be October 11, 2020, I guess it is?
3 years from the date of the order.
Okay, fair enough. Then I'll fill one in.
With that clarity on the motion, is there a second to the motion?
I second.
Is there any further discussion on that motion? Hearing none, we're probably discussed out. I think the motion is clear. All those in favor of the motion say aye.
Aye.
Aye. All those opposed, no. The motion passes by a vote of 4-1. Thank you very much, folks. Thank you for coming out. Meeting adjourned.